To my knowledge, if you ask any law student what is the toughest subject they read in law school, they'll say the word jurisprudence. Many practicing advocates come to know at a later point of their career on the importance of jurisprudence and its significance in dealing their cases. This presentation is an initiative to explain crisply on importance of jurisprudence in daily life of any practicing advocate. We can compare jurisprudence and interpretation of statutes as heart and lungs of a human body. It pumps the concepts of jurisprudence throughout the legal system towards achieving rational goals. I should have compared jurisprudence with the brain of a human being, but I just wanted to make it simpler to understand. One can always make their own analogies to understand a concept better. We all know law is broadly classified as substantial and procedural laws. I am not about to explain what a substantial law or a procedural law here because the goal of this presentation is to emphasize the significance of jurisprudence alone. So, what is law? Many philosophers and jurists had their own dogma in defining the concept of both law and jurisprudence. Though there is no any standard or fixed definition of law, being advocates, one should arrive at their own definition of law. I believe having a good understanding on jurisprudence and reading it consistently would make one to achieve the same. Jurisprudence is all about to getting accustomed with terms such as rights, duties, and several others as seen here and beyond. One can master substantial laws and procedural laws by mastering these terms and few other concepts of jurisprudence. I am about to share two examples here, one from procedural and one from substantial law, to simply explain how important it is to master these concepts. Anybody can set criminal law in motion is the basic principle of criminal law. Depending on the nature of the offense, a case starts its travel. If cognizable, a case starts with the FIR as per section 154 of CRPC. If not cognizable, then one has to file a case before the magistrate as per section 155 to set the law in motion. This all we know, but when it comes to offences relating to marriage under chapter 20 of Indian Penal Code, only the aggrieved person can file a complaint before court of law. A third party cannot file a complaint for such cases. This is a limitation of one's right to set criminal law in motion while dealing offences under chapter 20 of Indian Penal Code. Still, if a third party tries to make such complaint, the judge may reject on the basis that you are not the aggrieved person and hence you hold no locus standi. More specifically, section 497 of Indian Penal Code. Only a husband can file a case of adultery against his wife as it is interpreted as his proprietary right in the view that woman being dealt as a property of an Indian husband. Though this aspect is extensively dealt by our Honorable Supreme Court in various cases, the essence of this example is to explain the term proprietary right. Now coming to substantial law example, one have to understand the object of the substantial law while dealing with it. There are different kinds of rights as seen here. For example, you are writing a story. I have an obligation or a duty to supply you with all the pen, ink, and paper you need for writing. That is the positive right you hold over me, and the right you hold over me so that I should not copy that story without your consent is the negative right you hold over me. Intellectual property is mostly about to deal with one's negative rights. So, once we have a grip over the object of enactment and the right on which we are dealing will make our life easy while handling those cases. Finally, what is dealt under different schools of jurisprudence and what legal theory is all about. This is the place where concepts like rules of natural justice, ratio decidendi, Cyprus doctrine, laissez-faire, and various other concepts got born in the minds of various philosophers and jurists. And different terms such as rights, duty, power, liability were coined and given a rational meaning, which in turn effectively paved way for enactments of right legislations. Hope this presentation and narration made sense. With this, I am done with the purpose of this presentation. Thanks for watching. I am Satish, Advocate, Madras.